You're listening to What She Said on Canada Talks.
I don't know if anybody out there who's listening has ever been involved in a lawsuit, thought about a lawsuit. One bad neighbor is probably enough to make you consider it. Right?
Absolutely.
I'm sue you for
good
that,
fences make
for
good
that
neighbors.
fence that I hate. But in any event, we have there's certain steps involved, but it's really something you have to think about. Not only because it can take up years of your life and thousands of dollars, and in the end, you have to decide, is peace worth a price? Is your 10 years of your life worth a price? Or whether you really are entitled. And anyway, lots of steps. And we have Michael Salerno of DeRose Law, a personal injury law firm with almost 4 decades of expertise, who is joining us today. Hi, Michael.
Hi, Christine. Kate, thank you for having me back again.
Yeah.
Oh, you're welcome. So, I mean, okay, so what do you tell? Let's start at the beginning. So say somebody, wants to go through a lawsuit. I mean, do you give them fair warning of how long some of this stuff can take?
Definitely. From the very beginning, I outlined the entire process from literally our initial consultation to what eventually could happen at the end of the whole process, being trial. That is, in any event, the potential final conclusion to the entire matter. But what I do want to stress is that the last statistics I believe I saw for personal injury case in Ontario, about 97% of them never make it to trial. Okay, so although
That's huge.
it is huge, it really is an anomaly nowadays. We do live in a democracy and everybody does have the right to fair trial, but the reality is the way the system is set up, it is very disadvantageous to the average person who's been injured actually in a claim.
So it doesn't make it to trial because the insurance companies settle first, or because people just get so discouraged by the onerous system?
Well, it's very interesting because it definitely is a combination of both. Also, one thing I do want to mention, just because you do bring forth a claim for a personal injury, whatever it be, motor vehicle accident, slip and fall, any type of injury, whatever it is.
Or you get hurt at work,
Exactly.
or whatever.
It doesn't mean that you're necessarily going to litigate the claim. And by that I mean, it doesn't necessarily mean you're going to sue anybody. Now, everybody's practice is slightly different, depends on the lawyer that you're dealing with. But as you know, you only have 2 years to go ahead and actually sue an individual or an entity for some type of negligence that they've caused. However, my own personal practice, and generally everybody at DeRose, is to see if there is an opportunity to actually resolve the matter prior to suing anybody or litigating. And by that I mean within the first 2 years of the process, there's much fact gathering and information that must be obtained.
So, Michael, let me ask you this, though. Let's say somebody gets hurt, whether it be at work or in a car or on a sidewalk or whatever. Usually there's insurance by some party or another that covers. Usually. So in that case, you would go to the insurance. So why would you have to sue if they don't have insurance, or if they're not willing to pay you? They're disputing the claim.
Well, twofold. To touch on if they don't have insurance, if somebody doesn't have insurance, let's put aside the situation where it's motor vehicle accident related, because provided you have insurance, you will have coverage.
Yeah.
Okay. But let's say, for example, I have a few of these cases myself, a dog bite. Okay. If somebody does not have the appropriate insurance coverage under that, then you would have to sue them personally. Okay. And chances are that if that person doesn't have the appropriate coverage, they probably don't have any assets. Under that scenario, even though you may be able to obtain a judgment at one point, there may be nothing to actually get. Because if someone doesn't have anything, you can have a judgment for whatever you want, but if you can't enforce that judgment...
Well, just while we're on the topic, do dog bites come under home insurance?
Yes, they do. Yes, they do. Yes, they do.
Okay, I live in a condo. I don't have a dog, but I just want to know. Okay.
Yes. Now, sorry, to answer the second portion of your question, what happens is there's going to be an insurance company in place, let's assume, okay?
Yeah.
So prior to actually going ahead and issuing the claim, if the insurance company is going to make an offer that's reasonable, your client finds that to be reasonable in their opinion also, you resolve the claim. It's that simple.
Yeah.
It's a matter of actually getting together the productions and giving the insurance company and their adjuster the opportunity to actually properly evaluate the claim. The way that I look at it is, in my own personal practice, there's always 2 kicks at the can, okay? Unless it's a situation where somebody has a return to work, and we're talking about a pretty big income loss claim, or it's an attendant care situation where future care is necessary, or somebody with a pretty significant brain or head injury, those types of claims, generally you're not going to be able to resolve at the adjuster level, just because of the longevity that's required to find out what exactly this claim is worth. But your general claims where those issues are not really major issues.
Yeah.
My own opinion is if everybody's reasonable, there should be no reason that you cannot resolve it with the adjuster. Because the insurance adjuster, at the end of the day, is the one who cuts the check, regardless whether there's a lawyer hired later or not. It's their final say.
But you're saying over 90% never make it to the litigation. They
No, let me correct you. They never make it to trial.
to trial.
Yes, which is a very big difference. What I'm talking about here is pre-litigation, without getting a defense lawyer involved.
So why do they not make it to trial? So they file, they start a lawsuit,
Yes, so
but it never goes to court.
So what I've just discussed with you is the first 2 years prior to actually going
Okay.
ahead and issuing the lawsuit.
Okay.
Let's assume, for argument's sake, that you're unable to resolve the claim at the adjuster level,
Right.
and you're forced to go ahead and actually litigate the matter. So you have to issue a statement of claim in the courts. Okay, that's the first step. At that point, what happens is the insurance company, once you've served the claim on their insured, will go ahead and hire a lawyer. So now that they have their lawyer, whether it be in-house counsel, because there are some insurers that have their own in-house counsel. And
Oh,
there's
I'm
others-
sure they do.
Oh, they definitely do. And there's some that has a combination of both, right? I
Right.
guess depending on the workload. Their job is then to go out and hire a lawyer, and the lawyer will put together a statement of defense, which is basically a response to the lawsuit. They file that with the court, and then your first step is the examination for discoveries. And the examination for discoveries is something that most people find intimidating, unfortunately. But what I always tell my clients from the very
Well, what
beginning-
is it?
I'm going to explain that. So I have the opportunity to examine the defendant in the situation. So whether it be the owner or operator of a vehicle, whether it be if it's a slip and fall, maybe it's a maintenance company, maybe it's if it's a long-term disability claim, maybe it's somebody from the long-term disability insurer, whatever the case may be, I have the opportunity to examine them under oath with regards to anything that is relevant to the litigation. Okay. And what becomes intimidating is because on your end, as a plaintiff, if you're bringing a claim forward, the insurance company's lawyer has the opportunity to examine you under oath with regards to anything that is relevant with the litigation. So if you're putting forth an income loss claim, they're going to want to examine you about your life before the accident, as far as what you're doing at work, your income, your day-to-day functioning, and how that's changed. If it's with regards to your injuries, well, of course, they're going to want to know what your level of functioning was beforehand. Believe me, they go through all your clinical notes and records as far back as they can put an argument forth that may be relevant, and they're going to question you on all those particulars that they find in there.
So it's very intrusive,
It's
and
very-
and people feel very sort of that your privacy is invaded.
Exactly, and the thing is, I try to explain to my clients when I see that there's some fear or concern or hesitancy, you have to understand, when you are opening a lawsuit and you're litigating with another entity, you are telling them that they've wronged you somehow, and that their wrong has now caused damages to be made payable. So you have to understand, in all fairness to the insurance company, and believe you me, I'm not one to put something forth for the insurance company, but in all fairness to them, they need to know what your level of functioning was prior to and following whatever the incident may be, and why it is that they are responsible for making some form of payment to you. So yes, it is very intrusive.
Okay, so I mean, if we sort of bring us up to where we are now, so you've gone through to break it down. We've got the consultation with the initial meeting, then you've gathered secured evidence and all the documents about the accident. At this point, a lawsuit is started. Then you've got into discovery, where you're being questioned by both sides. Then there's another gathering of requested documents.
Correct.
So then so again, that doesn't come the first time. So this is, but then there's a chance for mediation that
Yes.
comes there.
Mediation actually is my favorite part of the job because it gives me the opportunity to sit across the desk from another counsel and their insurance adjuster, whoever may be responsible, who's overlooking that claim. Not every jurisdiction forces mediation. The only one really in the area is Toronto, and that has pros and cons to it. The pro is that obviously you are forced to sit down and be across the desk with your opponent for all intents and purposes to try to resolve the matter, but at the same time, because it is a procedural necessity, based on Toronto actions, a lot of the time it is a waste of time because the insurance company just isn't interested about settling a file, and they might show up and offer you something that's completely not within the range of acceptability. That being said, the process is much less intimidating for the client because very simply it's after, usually at this point we're 3, 4, 5 years into the litigation. Yeah,
Oh.
we're definitely down the road.
3,
at this
4,
point.
5 years.
And then we're only really at the midway point if it gets to this stage. And I've basically put together a very big brief, or let's call it an essay to put in layman's terms, outlining what exactly has happened to my client and why it is that the insurance company is responsible for making payment. I obviously have to include all the documentation to substantiate the claim, whether it be financial, medical, or otherwise. And I'm sitting across the desk with my client from the insurance company's lawyer and the insurer. And very usually we'll get a 3-4 page, very short brief saying why my client is not injured or why it is that the insurance company shouldn't pay much. They'll always latch on to the pre-existing conditions, how they're back at work and they're functioning and their life hasn't been affected. So you can see their take on it is usually very different from ours. And for the purpose of the day, there is a third-party lawyer who has no binding authority, but their job is, think of it as a broker. I always explain it to my clients, their job is to get a deal done. Okay? And the best mediators that I've worked with personally, I've heard it more than a few times that the proper settlement or the appropriate settlement is one that both parties leave feeling that they've left something on the table, because that chances are it's pretty reasonable in that case. We're not in the business to take advantage of anybody. I'm hoping insurers don't think that they're in the business to take advantage of us. It's to reach an amicable resolution. That's
Okay, but then what happens after that if you can't reach an amicable agreement?
Now we're to the point where the course of the litigation is much further down the road, and there are consequences that flow from continuing. Okay, prior to getting to trial, one of the necessary steps is a pretrial. Okay, and the pretrial basically it's similar to a mediation in the sense that much of the documentation and much of the legal arguments and necessary financial, etc., medical documentation has already been put together. It's kind of reframing that, and myself and my client sit with the insurance company and their adjuster. Again, this time it's in front of a judge. Okay, depending on the jurisdiction is different. Sometimes it may be in the judge's chambers. Sometimes it may be actually in the open court. But that's one last opportunity. Okay, and this judge again does not make a decision for you, but in often cases gives an opinion as to basically where they think they're at, and you hope that at that point both sides have that one last attempt to try to resolve it prior to getting to the culmination of the litigation, which is the trial.
And by now we're at 7 or 8 years.
Listen, depending on the complexity of the file, realistically you may be there at the 4 to 5 year mark based on a lot of the files we do, but in all reality you're pushing 7, 8, 9, maybe even 10 years that these things take in the system. And obviously this is the thing, the individual, this is their life. Okay, it is personal to them. It is much more of a grind than the insurance company who has thousands of these on their desk and it's just another file. So there's obviously a lot more incentive, or there is a lot more feelings and emotions on the plaintiff side than there is on the insurer side.
So then perhaps the first question when you meet with your lawyer shouldn't be how much is this going to be, it should be how long is this going to take?
Yes, and I always tell my clients this because that's obviously a main concern. There literally are some files I've resolved in 6 months, and there's some lingering in the office that take 10 years. Every file is different. There are complexities in some files that others don't have, and most importantly, and this is what I try to get out to my clients, most importantly on every file, if you look at it as a negotiation, sometimes you're dealing with people that are reasonable on the insurance end, sometimes you're not. Sometimes the client is reasonable. Believe me, there's times that the client is unreasonable. At the end of the day, it's a matter of dealing with people and emotions and how people's viewpoint is on a certain file.
This sounds like divorce.
But you know what?
Divorces to me.
It's not that far off.
Some of them are amicable and people are reasonable, and other times they're fighting over the purple teapot that both of them hate.
Yes, believe you me, and that's something that is unfortunate about the industry, but I guess it's like any profession in life, these things come up. You can't always deal with reasonable people and have things go smoothly. It would be everybody's utopia, I guess, if that was the case, right?
Well, thank you very much for coming in and scaring the bejesus out of us about lawsuits.
But it makes you think twice about what you're getting into. If you think, oh, I'll just sue them, well, you know, hey, think carefully about how much of your life you want to...
I want to stress that this is not necessarily going to trial. It's, like I said, 97% of things in Ontario do not.
Great.
All right.
Good news. Thank you, Michael.
Appreciate it.
Michael Salerno of DeRose Barristers and Solicitors, a personal injury law firm that has been informing and protecting clients for close to 40 years.
Click the channel subscribe button for full-length interviews and more from What She Said here on YouTube.